Welcome to AI for Good, the leading action-oriented, global and inclusive United Nations platform on AI. Organized by ITU, in partnership with 40 UN sister organizations, and co-convened with Switzerland. The goal of AI for Good is to identify practical applications of AI to advance the United Nations Sustainable Development Goals and scale those solutions for global impact. In today's session, we're counting on you to use the live video wall feature to ask questions and post comments to help create an engaging discussion. We encourage you to stay until the end to chat, connect, ask questions, and network with our distinguished panelists and world-class AI experts in the neural network. It is now time to kick off the session and welcome our first speaker. The floor is yours.
Hi, everyone. Welcome to today's webinar around AI and health. My name is Harrison, and I am a researcher in biomedical informatics at Harvard Medical School. And today, I have the privilege of kicking off today's session, where we are joined by Professor Salomé Viljoen, who will present her talk, What Makes Datification Legally Wrongful? And so just a brief bio about Professor Viljoen. She is an assistant professor of law at the University of Michigan Law School. She studies the information economy and information law. To this end, she is particularly interested in how information law structures inequality and how we may use novel legal arrangements to address said inequalities. Professor Viljoen studies algorithmic governance to bring legal insights into conversations over artificial intelligence ethics, algorithmic fairness, and machine learning. Professor Viljoen completed her legal education at Harvard Law School and was an academic fellow at Columbia Law School before joining the faculty of the University of Michigan. So again, it is my great pleasure to introduce Professor Viljoen as today's speaker.
Great. Thank you so much, Harrison, for that introduction. I am just now going to share my screen and get my slides up and get this talk going. Great. So today I'm going to be talking to you all about what makes datification wrongful kind of from a legal theory perspective, and why that matters. So first, I'm going to kind of give a review of what datification is, why we might think that it matters, that it's sort of socially and legally relevant. I'm going to offer some prevailing accounts in law and legal theory of what makes datification wrongful, and therefore worth regulating with various kinds of legal rights and arrangements with respect to data and data about people particularly, offer some thoughts about what I think those prevailing accounts miss, and offer my own sort of alternative account of what makes datification legally wrongful. I think this alternative account matters in the context of the UN Sustainable Development Goals for two reasons. First, I think this alternative account can help us identify where datification might be interacting with patterns of development and economic production that exacerbate the challenges that the Sustainable Development Goals are meant to address, like reducing income inequality, producing gender equality, facilitating peaceful and inclusive societies, and fostering decent work and working conditions. But second, and just as importantly, I think a more precise account of datification and our legal interest in datification can help us identify where the datification of social life, if governed differently and put to a different set of purposes and goals, can play a really key role in facilitating the Sustainable Development Goals, particularly by rendering legible key patterns of human behavior and interaction with one another in our environment that help identify helpful ways to act on the way that we relate to one another, to improve them. And that's really kind of at the heart of my interest in sort of reorienting how the law thinks about datification. So to start things off, what is datification? What do I mean when I use that word? What does it mean to say that we are datifying human actions and behaviors? So first of all, I'm going to be referring to datafication, particularly with respect to what I call social data, data about people. So not datifying, particulates in the air or water flows necessarily, but really trying to capture and datify human behavior and how humans interact with one another. So to offer a quick example, if I go to a coffee shop on 116th and Broadway in New York City, and I buy a cup of coffee, I can kind of, go into that coffee shop and hand over cash and buy a cup of coffee, or I can use my smartphone to tap on Square, another payment system, and I've kind of done the same thing, right? Like I've bought a cup of coffee, but in the latter example, that interaction is now datafied. So information on the purchaser, me, the seller, the store, the time of purchase, what I purchased, for how much, in datifying that interaction endows it with certain properties. So this interaction is now extendable across time and subjects. It's composable with pieces of information about other people and other transaction. And with these properties, I can sort of disaggregate this exchange between me and a coffee shop to understand when I bought the coffee, who I am, what coffee I bought, and I can recombine that with the data of others along various relevant shared features. So features about my purchase of coffee in the morning can be abstracted from that social exchange, and in this disaggregate form really take on a life of its own. It can be combined with other data to provide other forms of valuable insights, including some that might not be intuitive to me as I'm buying that coffee in the coffee shop. So perhaps time of morning that coffee purchases are made, it turns out to be a really reliable input to determining how safe of an investment I am for health insurers or creditors. It's not really something that I would intuitively think I'm in the business of doing when I'm buying a cup of coffee in the morning, is sort of providing information about myself as a credit risk. So features about populations that my disaggregated information can help constitute can emerge, so that people who have access to all of this disaggregated data can gain an idea of what these groups are, how they behave, and in turn act back on those populations. So a lot of datafication is happening. About 17 years ago, we sequenced the first human genome. That took about 3 gigabytes of data, which fills about a DVD. And in April of 2020, 23andMe, a firm which offers genetic testing, claimed that it had more than 10 million customers. So really amped up the amount of genomic data that's available. The latest autonomous vehicles produce about 30 terabytes for every 8 hours of driving. So according to this estimate that I have up here, the world will generate over 90 zettabytes, which is 90 billion gigabytes of data this year. And that's more than, in this year alone, more than all the data produced since the advent of computers up until about the year 2017. So really what we're doing here is we're sort of recreating in digital form representations of who people are and how they relate to one another along relevant features. So all of this data creates a lot of value, but there are also, of course, growing legal concerns about how all of this data is being used, and that can create all sorts of problems. So from a legal perspective, in the kind of legal academy, there's general consensus among scholars of law and technology that our existing approaches to data privacy law is inadequate to meet this moment of mass datafication, and that something must be done. But what exactly is kind of a topic of lively and ongoing debate. So there are sort of 2 prevailing accounts within law of what makes datafication wrongful, and therefore what law should do about it. The first is this account of unjust enrichment. And so the sort of story here is that data collectors, represented here by this castle, are like feudal lords, sort of getting this valuable form of labor, our sort of datafied impressions about our lives for free from all of us, the data subjects, who are sort of like serfs locked in by these large platforms to just sort of provide this valuable resource. And really, from a legal perspective, what this represents is a form of unjust enrichment. That large-scale data collectors are sort of unjustly or unfairly gaining all of the benefits and capturing all of the value of this valuable resource. And so the response in law is to grant data subjects or data serfs a wage or property right to the data that they generate. So sort of to equalize that relation by granting a right to payment and contract freely for their data value, either in the form of a wage right or a property right. And there are some prominent proponents of this kind of solution. So Andrew Yang has proposed data dividends as a way to sort of recalibrate the relationship between data subjects and data collectors. Sir Tim Berners-Lee, as a part of his project Solid, which is a Web 3.0 project, has also sort of proposed a similar way to allow people to sort of re-enclose the data that they're generating and demand a price for that data in a marketplace. The other kind of prevailing account in law, and I would say that this one is more prominent in the existing legal regimes that we have, is a sort of dignitarian notion of what makes datification wrongful. So whereas in the previous count, it was really kind of a quantitative harm that, there's all of this benefit being created from my data and I am not given any legal rights to claim some amount of that benefit back. That's really sort of a quantitative account of what makes it wrongful. Here, there's really sort of a qualitative theory of what makes datification wrongful. And it really has to do with privacy really being this good that secures the boundaries of the sphere of my selfhood. And what makes datification wrong is that it's sort of trying to pierce or render legible these internal aspects of myself in ways that can really sort of violate my dignity and my moral autonomy to determine for myself on what terms I am known and how much of myself I choose to make known to some sort of external observer. And this is really the basis for privacy rights in the United States, as well as to a significant extent in other parts of the world, notably in Europe under the General Data Protection Regulation. And so on this account, the harm that we're concerned about with datification is this sort of legibility harm, that there's sort of excessive apprehension going on, knowing me in a way that I didn't meaningfully consent to, and that therefore sort of violates this capacity to enjoy that privileged relationship to myself and self-formation. Even worse, there's a concern that if you sort of erode that barrier down, that allows me to sort of manage the terms of knowing myself and getting to know my own mind, that I'm sort of denied that necessary space I need to cultivate my own sense of self, my own preferences, my own sort of desire and way of acting in the world. And that I can therefore be sort of acted on in a way that substitutes the will of that observer or surveiller for my own, had my barrier of sort of self-formation been preserved. And so here we see a lot of concerns about things like manipulation, and surveillance as actually a way of remaking the subject herself, which of course undermines the moral autonomy and the legal agency of that subject. And so in response, the law tends to sort of propose stronger consent requirements to kind of thicken up that barrier between ourselves as legal subjects and these potential surveillors, and also to grant us more downstream rights about data that's being collected about us to minimize or prevent those forms of wrongful manipulation. So the goal here is to really reassert protections that sort of preserve the dignity of that inner life. And this looks like things like gold standard consent, banning certain forms of dark patterns that might sort of try to manipulate me granting consent, really imposing meaningful consent requirements, as well as downstream protections that limit how information about me can be used to sort of profile me or nudge me towards certain kinds of decisions. And here we see legal tools like bans on adverse automated decisions or more residual rights and control over downstream data usage for the data subject. And I think both of these accounts sort of capture important things about the digital economy, but they also, I think, really miss fundamentally how datafication actually works, how it functions in the digital economy to produce value, social value, as well as social harm. So what I want to kind of say is that debates in data governance law really focus on this kind of vertical relationship between a user like me and a data platform like Google or Amazon. And we really sort of focus on how the contractual arrangements between me and a data platform can be sort of constrained, what the terms are that they should contain, and how background rules like privacy laws can govern this exchange of data from me for services from them. And as a result, both of these sorts of predominant accounts that I just sort of laid out are really interested in focusing and intervening on this vertical relation. Generates questions like, what data can Google collect about me? How much value do they get from that data? Did I consent to this collection? And the scope of what that consent covers, right? Is it just sort of that initial exchange, or do I also kind of get these downstream rights? The problem is that this is a kind of incomplete account of the digital economy. So there's also, as I like to point out, this sort of horizontal relation, which is not between me and a company that collects my data, but is between me and other people. I'm going to refer to these horizontal relations as data relations, which captures the fact that data collected from me is almost never just about me. It's almost always also about others. This is like an obvious point to a lot of data scientists and even legal scholars, but I think it really is important. These data relations really speak to or express or capture the basic fact of our sociality, that we are like one another, that people like me can reveal meaningful things about me that are economically and socially useful. So this is a social fact that is coupled with new technological capacities like more processing power, new machine learning methods that are needed to actually sift through and sort and catalog and make sense of the ways that we relate to one another, and then act on those relations at the sort of scale and ubiquity needed to make socially useful and economically feasible those insights and predictions about people that arise from our data relations. So the point here is that these data relations are really key to how data about people turns into money for companies in the digital economy. And understanding this and taking it seriously has numerous ethical and legal ramifications, as well as benefits for clarifying what it is that we're in the business of as a legal community when we govern data relations. So this is all abstract. Let me give you an example of what I mean. So we have a data subject, Anna, who is 4 weeks pregnant. And ever since she began trying to become pregnant 2 years ago, Anna has used Apricot, a popular fertility tracking app and social media site where she uploads information on her ovulation cycle, eating habits, exercise patterns, sleep, mood changes, and a variety of other physical symptoms. Apricot aggregates and synthesizes all of this data that users share, not to sell people's data directly, which they reassure their users they would never do, but to sell insights about their user base to clients, such as advertisers, employment consultancies, consumer credit agencies, and others. And all of this makes Apricot a lot of money. After all, early pregnancy data is very valuable. Having a child is a big event in a person's life. It's when Anna is likely to change brand loyalties, purchasing behaviors. So advertisers and insurers and employers are all very sort of keen to be the first to get to know and to reach Anna in this state of flux. But of course, this lucrative time is also a risky one. The legal status of Anna's first trimester pregnancy and her decisions about whether or not to stay pregnant are both very personally and legally fraught. First trimester pregnancy data is vulnerable in other ways as well. Potential or current employers, creditors, or insurers may also be interested in knowing who's about to, I don't know, experience an extremely expensive and disruptive life event, and who on the flip side is likely to be a reliable, healthy, productive worker. Which is not to say that those entities want to specifically target or identify pregnant people, but that the autonomous systems increasingly used in those sectors to sift and identify candidates are designed to optimize for low-cost, low-risk people, and are thus primed to sort of identify and exclude the pregnant, even if wholly unintentionally. And it should come as no surprise, privacy and data governance law is very attentive to the potential ways in which this data flow might exploit Anna or put her at risk. So let's imagine we adopt one of the sort of two accounts that I just had put out. So if we're propertarians and we're worried about unjust enrichment, we might say, okay, we give Anna a property right in her data, a wage right to her data so that she can get paid a good amount for her data from Apricot. Or if we sort of are worried about legibility harms, we would say, okay, we're going to impose really robust consent requirements on the terms of the collection of this data, make sure that Apricot is promising that it won't be used to make any harmful choices about Anna. And in some sense, from a US perspective, that would be a real progress. That would be better than we often have now. But it doesn't actually correspond to why data about people like Anna is so lucrative and ubiquitously collected, which has just as much to do with our friend Becca. So how is data about Apricot sort of used in a real world sense? Again, we have Anna who uploads all of this information about her fertility and her pregnancy to Apricot. Apricot sells insights about their user base to clients who in turn are combining that sort of pregnancy and fertility data with other data sources and other kinds of behavioral insights. For example, data on users' TV viewing habits and their movement patterns. Because again, all kinds of entities are very interested in the behavioral signs and patterns of early pregnancy. So Becca, who does not use Apricot, fits the behavioral patterns that emerge from the analysis of Apricot users. Like Anna and others, she exhibits the same patterns of changed TV viewing and online purchasing behavior that indicates that she too is likely to be or is in fact in the first trimester of a pregnancy. And indeed, a prospective employer relying on the services of an autonomous profile sorter flags Becca as a high-risk candidate, and she's eliminated from consideration for a job. Now, the rights that we've given Anna, strong consent requirements, maybe a property right, they do not correspond to this horizontal relation. So we haven't really done anything to protect Becca in this situation. So if we, again, sort of map things along the vertical axis, things are looking pretty good for Anna. She has meaningful consent. She maybe has a wage right. But we haven't really grappled with the fact that data about Anna's pregnancy is really in this sort of fundamental way also data about Becca's pregnancy, in that from a legal perspective, this data is being used to make predictions or guide behavior in ways that impact Becca too. And this isn't some obtuse correlation. It's a salient relationship in that at least potentially or arguably a legally relevant thing has happened to Becca here. She's been denied an employment opportunity on the basis of her pregnancy status. To complicate things a little bit more, horizontal relations are actually sort of population level relations arising from those population correlations and patterns drawn across groups. So Anna is not just in a horizontal relation with Becca, but potentially anyone in population J. You can say all the Beccas that share the sort of relevant pregnancy indicating features with Anna. And the same is true the other way around. So it's not just Becca that is in relation with Anna, but sort of all the Annas that might potentially indicate some sort of pregnancy indicating feature that Becca is in a horizontal relationship with. So that's kind of obvious to a room of data scientists perhaps, but from a legal point of view, what this means is that these horizontal ties give rise to population level legal interests. So insofar as either Becca or Anna have some legally protected interest in how pregnancy data is used to make decisions about them, that interest accrues or it attaches at that population level. It's implicated by the choices of anyone who shares indicia of the population feature. And these horizontal relations are data relations. They're the point of data collection in the digital economy. So relating people to one another is not like exhaust or pollution that just kind of happens to arise as these companies collect fine-grained information about Anna that they stick in the Anna folder. No, these relations are the basis of how money is made in the digital economy, why data is collected by companies like Apricot, and how that data is incorporated into the playbooks of success of some of the wealthiest companies in the world, in the digital sector and increasingly in other sectors that are looking to emulate the wealth and success of the data economy. So there are sort of three things that become clearer on this account of what datafication is. and what might make it legally wrongful. The first is that consent at the point of collection just doesn't operationalize its own account of what makes datification wrong. So this account really offers a strong challenge to the prevailing use of interpersonal contractual consent to govern our data relations. Now, a lot of other people critique notice and choice and notice and consent-based privacy rules, but I think this account offers an especially strong challenge, which is not just that consent is difficult to get because people are likely to be manipulated, or consent doesn't capture all of the downstream things. We're not good at like assessing the risk of handing over our data. But rather conceptually, consent is just the wrong fit as a legal tool. So consent isn't just wrong because these exchanges are subject to manipulation. It's like a category error, even if we had gold standard consent. Because the theory behind consent, when we in the law deploy it to offer legitimacy to any given exchange or any given relationship, is that I can't consent on behalf of another, and another can't consent on my behalf. I have to do it for myself. But that's what's happening all of the time, constantly and fundamentally in the data economy. And that really suggests the need for other legal forms that capture those legal relations that we're being placed into and can meaningfully negotiate the terms of their legitimacy. The second kind of upshot is that these prevailing accounts that really just focus on the vertical relation between data subjects and data collectors isn't indexing a lot of the ways in which datification might be considered wrongful, which is not because of some interpersonal violation of my sphere of autonomy, but because the data relations being apprehended between myself and other people are being acted on in a subordinating way to the overwhelming purpose of private profit generation. And so this reorientation to really focus on how we are being placed into datafied relations with one another can draw attention to how we might be drafted into the project of subordinating both ourselves and others like us as a condition of being a social being in a digital world. So if we return to the fertility tracking example, if we take sex to be a category defined by difference, oftentimes socially imposed difference, that is situated in a world that is sex and gender stratified, then part of how sex groups are constituted or is as a group of people, like, so let's take women as a sex group. Part of how that group is constituted is as a group of people for whom, in order to gain equal political, economic, and social standing, it is required to gain control over the means of reproduction. And for whom denying such means is part of constituting this category in a socially and materially subordinating way. So indeed, making reproduction a central part of women's identity, how they spend their money and their time, how they craft their identity and their sense of self-worth, is the point of altering legal rights around reproduction. So this legal arrangement is in service of a goal to advance a conception of women as those people who can be drafted into the role of motherhood, and that posits motherhood as the idealized form of what women ought to aspire to and find meaning in. So what I want to suggest is that part of what we are doing when we datify indicia of fertility and use those indicia to infer, predict, or guide human behavior is to rematerialize one relation among women that helps to sort of constitute a potential category of difference. And that in turn presents sort of a filament in the social constitution and social structure that can be acted on, activated or reconstituted as a means that might make that group, sort of women, a socially subordinate one. And if we think about that account of what makes datification wrongful, not that it's a problem of me being sort of personally, my like sphere of autonomy being violated, but that it's potentially like doing the social subordination on me by like making or apprehending me as a woman in this potentially risky and vulnerable and socially subordinating way, we can sort of reorient to a different set of legal goals and agendas, because the law does not typically assign us individual rights over features of group subordination. So I can't, in theory, sign away my right not to be sexually harassed at work, though of course there are all sorts of provisions that might mitigate my capacity to express that right. This kind of alternative account that really looks at datification as sort of rematerializing our social relations also makes clearer, in my view, kind of the social and distributional consequences of datification, how it can exacerbate not just sort of relational or social inequality, but distributional inequality too. Of course, some of the wealthiest companies in the world rely on that business of datafying social life that really sort of requires and prioritizes data production as a key competitive advantage. And focusing on datification as sort of a social process, I think also helps us sort of grapple with the potentially economically unequal effects that datification can have. But what I also want to emphasize and maybe close on is that reorienting our account of what makes datification wrongful from this kind of individual apprehension or like quantitative, like I'm owed my piece of the pie accounts to this sort of understanding of socializing the relations that we are being placed into, or datafying the social relations that we are being placed into and acting on those social relations. Also, I think really suggests the role that datification can play in solving a lot of the most pressing challenges that we face. So those same social filaments that help us make sense of how we relate to one another, understand ourselves as social entities that are being datified and that can rematerialize or exacerbate forms of social inequality, can also be activated and reconstituted as a means of addressing or erasing those forms of inequality. So in a sense, all I'm pointing to here is sort of like a central motivating tenet of social scientific inquiry into the world. But the point is to understand how people are placed in the social structure in order to change it, to improve it. And that starts with apprehension, really understanding how it is that we are placed in relation with one another so that you can begin to identify points of intervention to sort of recalibrate and re-equalize the ways in which we relate to one another socially. So legal rights that poorly index who has a stake in data production aren't just a problem because they might not capture the ways in which being datafied are harmful to people, but they might also be a problem because they prevent socially beneficial data use. And there are sort of two ways that an overly strong individual consent right might prevent socially beneficial data production, but I'm going to focus on just one. So strong negative rights against having your data collected by a data collector, they don't just apply to the legal subjects that we might think need further empowerment. They don't just apply to the Annas and the Beccas of the world, who we want to guard against excessive nefarious legibility. They will also apply to entities like polluters, chronic wage theft violators, landlords that might be abusive, or discriminatory employers. And these subjects, given strong rights against collection, may be empowered with claims against being rendered legible for non-nefarious regulatory ends, like climate action, imposing higher labor standards, achieving better housing, and securing fairer working conditions. So, understanding what makes datification potentially bad as the social relations that it rematerializes and can exacerbate also suggests that datification in the service of legitimate shared governance goals that are looking not to sort of institute or materialize relations of subordination, but are actually looking to equalize those relations of subordination and impose sort of positive interventions ought to be generally permissible and sort of widely allowed. So I think I'm going to stop sharing there and turn things over to discussion. Thank you.
All right, so thank you so much, Salomé, for the super intellectually stimulating talk. And at least I'm just speaking for myself. This is the first time I've kind of thought really intricately about law and legal arrangements with regards to our data. So I found it to be incredibly interesting to listen to. So as we wait for questions to flow in from the neural network, I'll get started with some of my own that I kind of thought about when you were talking. So the first question I had was, you mentioned at the beginning of your talk that the legal field proposes stronger consent requirements to prevent these companies or these other institutions from denying us the agency to have governance over our data and how we're perceived. And to this end, you mentioned like the gold standard for consent. So I was just wondering, could you give us some intuition for what this technically looks like? And, is this kind of what a lot of us in the biomedical field think of as informed consent, or are they, two different things? And kind of compare it to what it should be ideally in theory and how it's actually panning out in the real world currently.
Great. Yeah. So when legal scholars talk about gold standard consent, what they're talking about is a consent relationship where like all of the theoretical conditions of consent have been met. So in contract theory, I mean, in basically like the basis of all private law, where like, one thing you learn on like day one of contract law in law school is that a contract is just an enforceable promise. So when do we hold people to the terms of the promises they've made? We hold people to the terms of the promises they've made when we think that they've given those promises in their full capacity as a moral agent. Like, I've decided to reallocate some of my like freedom as a moral agent in the world over to this obligation to you. And I'm going to be held to that promise if the conditions of gold standard consent in theory have been met. So what does that mean? It means that I understand fully what it is that I am agreeing to. I think it's a fair exchange. So whatever I'm agreeing to give you, you're agreeing to give me something in return. And I'm like, yes, I am getting the benefit of my bargain, as we say in law.
Right.
And so I fully understand all of the conditions that I'm agreeing to. I agree to them freely in my sort of capacity as like a moral agent responsible for my own kind of choices and decisions. I'm free to make them, and therefore I'm obligated to abide by them. And that's kind of what we mean when we talk about gold standard consent. It does, I'm sure, I mean, that's what people who are trying to sort of in bioethics and biomedical research are trying to achieve when they talk about kind of informed consent, or meaningful consent is another term that we'll see, that I really mean that I agree when I say that I agree, and I agree freely, and I agree with full knowledge of everything I'm agreeing to. And that's kind of the theory. That's what we think gold standard consent achieves. And there's also kind of like a moral theory of why we think that you should then be bound by the terms of that obligation. Now, in practice, of course, it's very difficult to achieve that. We sort of have like an asymptotic relationship with gold standard consent in
Right.
most of the contracts that we agree to in the world. And what I'm trying to point out is that like there are a lot of ways in which gold standard consent is not achieved in the terms of service that we click on when we click on every website and things like that.
Right.
And people make those arguments all the time. I wasn't given a chance to negotiate the terms of that agreement. I didn't read that agreement. I don't really have an opportunity to walk away from that agreement, right? All of those things. People talk about dark patterns, how apps will be designed so it's super easy to opt in, but really difficult to opt out. Those are like dark patterns that are trying to manipulate me and nudge me into saying yes, but I might not really like mean it fully. And part of what I'm trying to say is like all of that is true, but even as a theory for like when the law says that consent works to grant legitimacy to a thing, the way it works is that, let's take people coming into my house. The reason that consent works to sort of adjudicate legitimacy for, if you're in my house with my consent, we call you a guest, and that's good. If you're in my house without my consent, we call you a trespasser, and that's bad. And like literally the difference between a guest and a trespasser is, are you in my house with my consent or not? And that sort of like legitimacy switch is flipped by consent because we think it's like up to me. Like I can consent on my own behalf to let you into my house. Somebody
Right.
else can't give you permission to enter my house. That's not how consent works. Like no legitimacy has been granted. And so part of what I'm pointing out with the digital economy is that others are consenting on my behalf all the time. Like I could never use a fertility tracking app, but because enough people who share enough population features with me are using fertility tracking apps, like those same uses, those same insights can be made about me. So consent doesn't do the legal work it's supposed to do, even in theory, even in its gold standard form, to protect me against the kinds of things that we think data governance law ought to be protecting me against. So that's kind of my relationship to gold standard consent in this context.
Wow, very interesting and very raises a lot of different questions to think about.
Yeah.
So in terms of like, how do we think about addressing this issue at like a very, very high level? I was just curious, like in terms of actually using law or, writing new laws, how is there any progress or is there any arrangements that people have thought of to try to think about this issue where, you're, even if you aren't consenting, these organizations can still somehow learn about you by using other people's data or, using data that you never consented to?
Yeah. So, I think that there are a few ways that law sort of tries to grapple with this. So one is that it can recategorize what it means to say like data about you as inferred data. So even if I never used a fertility tracking app, for instance, so you don't have direct data about like my fertility status. If there's inferred data about me, where again, you're sort of, I'm Becca and you're using data gathered from Anna, you're combining it with my TV viewing habits. You're like, okay, I think there's like an 87% chance based on Salomé exhibiting the same changed TV viewing behaviors as people that we know are pregnant from the apricot population. Do we like infer that she's likely to be pregnant? The law can recategorize that inferred data as data about me that I have granted protections and rights in. So that's kind of one way that legal rules and legal regimes can kind of try to capture that I don't know, how data produces insights about people. The other is really use restrictions. So that's to say, and I think that there's more promise to sort of balance the harms and the benefits of datafication. Though they're harder, they're obviously harder to agree on and they're harder to enforce. But saying, for instance, it's fine, you can collect fertility data about people, but you're only allowed to use that information to further public health goals, for example. So it's fine to collect fertility data about people if you're using it to gain further insights about early pregnancies and sort of to do medical research on the status of early pregnancies. Or, for example, you do want to use inferred data to make decisions about the Beccas, but instead of it being like Becca being denied an employment opportunity, maybe there's information that Anna and Becca share indicia of a vitamin deficiency in the first trimester of their pregnancy. And you use that information to target everyone that's likely to experience that vitamin deficiency with like a 75% off coupon for those vitamins from a local pharmacy. So we might not want to restrict that use, right? And so we might not want to, place bans on anyone ever collecting fertility tracking data because there's a lot of socially beneficial uses. But by looking at kind of like that relation and how we are sort of datafying social relations and saying, okay, there are uses that are socially legitimate, socially beneficial, public health intervention uses. And then there are uses that are maybe like doing sex subordination on people. Let's make illegal the sex subordination uses, but let's foster the social beneficial uses. Now, that's maybe a optimal solution in that it prevents the socially harmful uses and optimizes the socially beneficial uses. But of course, it's also more politically difficult because we might disagree on what the good things and the bad things are. So yeah, that's sort of the range of possibilities in law and in these conversations in law right now.
Okay, very cool. Good to know. We actually do have 2 questions from the audience as well. So sure. I will read out loud the question from Aurelio Garcia. He says that he was wondering about the cases when there is an intermediary in the process. For example, when schools decide to use a given private learning platform with their capacities for data extraction, etc., while parental consent is required, this additional layer makes informed consent more difficult. And he wanted to know, does it make it more difficult? And what is your view on it, or what is your legal recommendation for how we may deal with it with regards to law?
Yeah. So, I think that these kinds of intermediaries or third-party uses are all instances where, you're imposing kind of like additional reasons why consent might not be the best way to govern a data flow. So who's to say that the parent is necessarily fully aware of what they're agreeing to? Who's to say that the child's interests are best being sort of like perfectly protected by parental consent? All of those sorts of adding agents and steps and actors into the picture is just going to sort of weaken the consent function. But once again, I actually think that even if we had like amazing gold standard consent, we might still need, we might still be sort of missing a lot of what we might worry about by datafying education data. And so, in this context, again, I think legal recommendations, to me, it makes more sense to think about use restrictions or other kinds of sort of like structural governance management mechanisms for things like education data. So we might say, okay, it's fine to collect education data, but we're going to impose robust standards on what we do with that data, how we treat it, what we use it for, how long we keep it. I think a lot of the sort of legal recommendations that I think are really useful are sort of recognizing that a lot of kind of risk in data misuse comes from information just being around forever. And sort of, I don't know, a rough intuition is that the longer it's around, the more it can start to get used for purposes that are pretty divorced from why people wanted to collect it to begin with.
Right.
So things like retention limits on information, particularly, educational information about children in elementary school. Maybe we don't want those all that sort of rich education data following them all the way through to college and sort of constraining their future opportunities in this sort of like long-term downstream way. So we might say, okay, fine, you can collect detailed education data about your child's educational status in second grade to help them like do better on their assignments and to give parents insight into how their child is doing. But maybe at the end of second grade, all of that gets deleted. Or if we're going to retain it, it gets retained in aggregate form. It gets held and managed by data stewards who are like public education researchers, and it's held in a sort of data repository with that specific mandate in mind that can impose, again, as I said, those use restrictions on that data. So maybe we allow long-term access to that data if we want to give social scientists like really high quality longitudinal data about educational achievement, which is extremely socially useful to have, but the reasons that we're sort of allowing that information to live on and the sort of legal rights that we impose on data the longer it's been around are probably ought to be sort of narrowly tailored. And for researchers or data scientists to grant access to that data, they probably need to be meeting a higher and higher threshold, IRBs,
Right.
and showing like proof of socially useful reason to gain access to this data, and not just letting all these private companies sit on repositories of very sensitive data forever, which is weird in law. I mean, like other intangible assets, we don't tend to grant companies like permanent access to. But that's another conversation that I'm happy to get into.
Okay, thank you so much for your response to that question. The next one is from Jacob Brun, and he's asking you, what are your thoughts on open source artificial intelligence and model interpretability? And I guess he specifically wants to know your thoughts on how that relates to, and how openness can relate to preventing or even increasing abuse of data.
Mm-hmm. Yeah, so have thoughts about model interpretability, but they don't really derive from my normative legal theories on data. So I'll focus on the open question more. And there, I think I'm going to be an annoying lawyer and legal scholar and say, I think the devil is really in the details on what we mean when we say open source. So in general, I would say I probably am an outlier in the privacy law community in that I am a bigger proponent of things like publicly held and managed data sources, open data curation, open data sources. I tend to be more in the camp of wanting to increase the set of actors that we give a right to access social data resources rather than decreasing the sets of actors. But I think that in order for those things to be operationalized in a way that achieves the benefits of increasing access while mitigating the risks and the harms of increasing access, really has to do with sort of like tiered access governance mechanisms. I'm a big fan of tiered access governance mechanisms. So what do I mean by that? What I mean by that is that like open is not this binary, like, we're taking the data, we're taking, social behavioral data from a social media platform, and then we're just like posting it on like some sort of resource for anyone to download. No, we should open up, again, I think that I don't think there's like a neat relationship between risk of harm and secrecy, because data can be held by one data collector and still be used to make very harmful decisions about people by that one actor. So I don't think secrecy necessarily protects us, but nor do I think that opening up access to data is just risk-free. So again, I think that if openness means something like some sort of public agency or public entity employing data scientists that give us sort of like high-level insights and metrics about the data sources that are potentially interesting and useful, that's great. More granular insights and sources in order to gain access to that data, presumably I would want it, or in my ideal world, researchers would have to then go to that repository or that agency and say, okay, here are the questions that we want to ask. And here's why we need access to your data source to ask these questions or to develop this model. And they kind of have to make a use case. They have to sign an agreement that constrains what they're going to be using that information for, and then they can grant access to that information. And maybe in order to grant access to like granular individual data subject data is like an even higher threshold level. Like you have to do all of your computation on a secure server. We're going to hold you to like very defined, not just like general uses, but like this specific research question. We're going to publish on this specific research question. Okay, you gain access, you've made a use case. It's gone through sort of like a board review or a committee review. We're going to grant you access to the granular data sources. The more sensitive the data, the tighter the controls. But I don't think that the way we do it right now, which is just saying, too bad, companies have a de facto property interest in that data. Researchers can't gain access to it. Better just try to like go hat in hand and like beg is the right answer either. So again, I think paying attention to all of those sorts of intermediate governance mechanisms that are somewhere between totally open and totally closed is exactly the way to go.
Great. And then a follow-up question from Jacob is that he says that a lot of what you discussed today reminds him of the public good and the tragedy of the commons from Lloyd and Hardin, I guess. So he's asking, how do laws generally handle that with regards to data, at least, I guess, existing laws?
Yeah, I mean, I think a lot of the problems we're in right now with respect to data governance law is that we don't govern data as a public good. We kind of artificially reimpose excludability on data by granting companies essentially a de facto property rights in data. They can assert trade secrecy protections against having to turn over data sources that they collect. And they also then sort of appeal to the contractual relationships they have with me, the data subject, that says, I can't turn over this data to this third party because that would violate my contractual arrangements with Salomé. So, what we have right now is a governance mismatch. So public goods can be well governed in law. You just sort of need to come to grips with how to manage them. And oftentimes what that looks like is sort of managing the economic interests we might have in generating and collecting a public good, and making sure that you impose enough sort of exploitation rights in the public good that you're generating enough of it to be socially beneficial, but at the same time also opening up all of the socially beneficial uses that come from that public good so that they're not exclusively captured by an economic agent. So we don't do that currently with data, but in other intangible assets, which are also considered public goods, the law strikes that balance by granting a limited monopoly right in the initial exploitation. Because again, the problem with public goods classically is that they tend to be sort of underinvested in, underproduced. And the way we fix that in law is we say, we grant you a limited monopoly right. So that's what patents do, right? We say, okay, I mean, the problem with an intangible public good, right, is that anybody can replicate it. And so what do? We legally impose a monopoly right for the original inventor or filer of the patent, not always the same, to exploit the economic benefits of the patentable good. But after a certain point in time, we think that the kind of cost benefit analysis shifts, and that now, in order to also promote all of the public good that this invention can foster, we're going to let that monopoly right expire and let everyone generally exploit the good. And we do that with all intangible assets. Copyrights are the same. After 75 years in the US, your copyright monopoly interest expires, and anyone can sort of freely use the expressive work. So that's sort of classically how the law negotiates and governs public goods to kind of optimally balance our interest in producing enough of them with opening them up for general sort of socially beneficial exploitation. We're just not doing that with data.
Great. And then I think this is going to be our last or second to last question from Pavel. He was wondering if you knew about the EU Data Governance Act and the upcoming Data Act. And if you do know about it, what's your view on it? And if you could just kind of give us some of your thoughts.
Yeah, so I know generally, so there's the, I don't know about this data governance. Is it the there's a Digital Markets Act and there's a Digital Services Act upcoming. I know a bit about those. I'm generally in favor of both of them. I mean, in general, I would say the EU is one of the better jurisdictions on data governance. I do think they still rely on consent a little bit too much. They don't only rely on consent. All European data governance scholars would say consent is only one basis for legitimate processing, but they do still kind of have kind of a consent-based, not fully, but partially consent-based view that I don't think, for all the reasons I just said, is particularly effective. But right. I haven't looked specifically at the upcoming, if there's like an additional upcoming data act, because EU is very active in this area. I haven't looked at the specifics of that, so I couldn't comment specifically on what I think about those. But in general, I would say things like the Digital Markets Act that recognizes kind of like the infrastructural role that large scale data collectors play in trying to open up access to the relative benefits of that infrastructure and that infrastructural advantage, I think are a good thing. Now, do I think that they go far enough? Not always. I would love to see more efforts in the EU to sort of open up researcher access to data as sort of like not just like a thing that's allowed, but a thing that's sort of actively incentivized. And there are people writing about that and thinking about that in the EU context. But yeah, that's sort of a high level overview and may not be responsive to the particular act that you asked me about, but yeah, that's kind of my general impressions of the EU approach, which I tend to be more of a fan of.
Okay, great. Thank you so much for offering your insight. Yeah, the question was non-specific. So I think either way, you did a great job in answering it.
Thanks.
So last question is just from me. I wanted to know, it's way less technical. I just wanted to know, this field or this area of data information law that you're in, I feel like it is probably, just from my intuition, a relatively younger field compared to like civil rights law or like corporate law, bankruptcy law, that type of stuff. So I was wondering, for your personal journey, how did you kind of find your way into this newer area of law, and what like, did you have any personal experiences, or how was your journey into this field look like?
Yeah, Yeah, so it is definitely like a younger, newer field. Though, in law, these things are maybe older than maybe in some other fields. So it's about, well, Brandeis wrote a famous law review article, The Right to Privacy, in 1895. So sort of the birth of US privacy law. Information privacy really came onto the scene in the mid-century. So in the 60s and 70s, a lot of people were writing about as sort of the federal government was digitizing and computers started getting on the scene. But yes, it is definitely a fairly young field. I found my way into this through consumer protection and predatory lending work. So I was doing a lot of work on predatory consumer practices, particularly predatory lending practices around things like for-profit colleges or payday lending and payday loans. So really kind of came to this through the very surveillance-heavy kind of consumer credit world, and how I sort of really saw that exacerbating a lot of the problems in predatory lending that have been there forever, but are really amplified by problems of mass datafication and surveillance. So that's kind of how I found my way into privacy, through consumer protection.
I see. Very interesting. Very interesting. All right. So I think that concludes today's session. Thank you so much, Salomé, again, for such an incredibly interesting talk. I know I'm speaking for myself, but I certainly learned a lot, and I would be keen to learn more about this and read more articles about it. So again, thank you so much for joining us today. And now I'm going to hand it back to Anna.
Great. Thank you so much for having me.
Thank you for participating in today's AI for Good session. We hope you've learned something new, innovative, and engaging in today's event. We now encourage you to continue the conversation on the live video wall in the neural network. Here you can ask questions, like and comment, share links, complete the poll, connect with interesting profiles, or speak one-on-one using the chat and video function. After the networking session, we invite you to explore the lobby, try the smart matching quiz, visit the virtual exhibits, poster boards, the e-shop, and build your personalized AI for Good program. Let's shape the future of AI for Good.